Hello everyone, my name is Amber Rouse Holloway and welcome to the May 2023 episode of My PIP Monthly. Our May 2023 topics include a case law update. First, we'll talk about the case of Mapp v. Progressive, which is a published opinion rendered in 2023, so a very recent published opinion. Then we will go on to talk about the cases, these two cases in conjunction. The first one is going to be C-Spine Orthopedics v. Allstate, which is an unpublished opinion issued March 30th, 2023, and then we will move on to talk about C-Spine Orthopedics v. Progressive. And after the case law update, we'll move on to trending topics in PIP litigation. Today I wanted to discuss a little bit more on the one-year back rule. I know that's kind of been a topic the last few months in the trending topics section of My PIP Monthly, but we had these two cases that coincide and will definitely affect the way the one-year back rule is defended. So first up, it'll be the case of Encompass Healthcare v. Citizens, which is a published opinion, and then I'll briefly talk about Spine Specialists of Michigan v. Esurance, which is an unpublished opinion that was recently issued April 20th, 2023. First up for our case law update, we have the case of Mapp v. Progressive, which is a soon-to-be published opinion. This case pretty much centers around the term domicile and what that means for litigation and what that means for the named insured or persons covered in the policy. As we all know, the No-Fault Act requires that personal protection insurance policy cover the person named in the policy, the person's spouse, and a resident relative of either domiciled in the same household. Now, domicile is a legal term of art. Its meaning as it relates to the No-Fault Act was discussed in the case of Grange Insurance v. Lawrence. According to the Grange case, a person may have only one domicile, but a person may have more than one residence. And for purposes of distinguishing domicile from residence, Grange explained that domicile is acquired by the combination of residence and the intention to reside in a given place. If the intention to permanently reside in a place exists, a residence in pursuance of that intention, however, will establish a domicile. Moreover, the traditional inquiry into a person's domicile is generally a question of intent, but also considers all of the facts and circumstances taken together. And that's what the case of Mapp v. Progressive points on, that it's important to look at all of the facts and circumstances taken together and not just one or two things. Now, we all know that the No-Fault Act itself is what controls coverage, what type of coverage is provided, and all mandated coverage. But it's also possible, as noted in the Mapp v. Progressive case, that a policy may expound upon benefits, but the No-Fault Act specifically requires that certain benefits are provided. So basically, a policy can provide for broader coverage than is required by the No-Fault Act or the statute, in which case the policy may be enforced as written. Again, while a no-fault insurer must provide at least the minimum coverage required by the statute, i.e. for relatives domiciled in the same household, it may provide coverage for a broader group of persons, relatives residing in the name insured's household, if that policy provides so. So this case, essentially, the term domicile or definition of domicile was expounded upon in the policy of insurance here, and therefore the policy of insurance had to have been adhered to instead of just the No-Fault Act. Next up, we have the case of C-Spine Orthopedics, PLLC v. Allstate Insurance Company, which is a recent unpublished opinion. It's important to note that this case is nearly identical to the factual scenario that was presented in the published decision of C-Spine, which I will refer to as C-Spine 1. But here, the trial court, in granting summary disposition in favor of Allstate, ruled that C-Spine was not a real party of interest and lacked standing at the time the action was filed. In the instant case, the court felt that it was compelled to follow the ruling in C-Spine 1 and therefore reversed and remanded the C-Spine v. Allstate case and concluded that C-Spine did indeed have statutory standing under MCL 500-3112 and therefore has standing in this case and is the real party at interest. A brief background into these C-Spine cases. Essentially, the cases involve what's called a factoring company. Factoring companies provide financing to business with cash flow issues by purchasing outstanding invoices at a discounted rate. And in exchange for sums paid by the factoring companies, medical providers assign them their rights to bring first-party lawsuits seeking payment of the outstanding invoice balances. And that's what happened here. When the medical provider then files a claim for reimbursement against a no-fault insurer, the issue becomes whether or not the medical provider was the real party in interest or has standing to sue at the time the action was filed. Now, C-Spine 1 held that under MCR 2.201B, an action must be prosecuted in the name of the real party in interest, subject to several qualifications. This procedural rule requires that a complaint be brought by the party to whom a claim belongs or by a party who has the legal right to have a court consider a claim. Here, standing is not a barrier to C-Spine's case because MCL 500-3112 grants C-Spine the right to assert a direct cause of action against an insurer to recover overdue benefits payable for charges, products, service, and accommodations provided to an injured person. Ultimately, the court in C-Spine held that the real party at interest rule here did not preclude C-Spine's suit either, explaining that a real party in interest is one who is vested with the right of action on a given claim, although the beneficial interest may be in another, which is the case here. Here, the beneficial interest was actually with the factoring company, but the court held that C-Spine was a real party at interest because it was vested with the right of action. Again, C-Spine is vested with the right of action against Progressive here based on an assignment from the injured motorist and was therefore authorized by statute to sue in its own name under the plain language of MCL 500-3112. The fact that the beneficial interest resided with the factoring company did not necessarily eliminate C-Spine as a real party of interest. And back to the unpublished opinion of C-Spine Orthopedics v. Allstate. Essentially, they applied C-Spine 1, and the court was left with no choice but to conclude that C-Spine had statutory standing and was able to sue in this case as it was the real party in interest. Alrighty, moving along to trending topics in PIP litigation. Again, I wanted to discuss some more cases on the one-year back rule as it's been a topic that has come up frequently and it has been requested by a few of our listeners as well. First, I want to briefly talk about the case of Encompass Healthcare v. Citizens, which is a published opinion, and then the recent unpublished case, Spine Specialists of Michigan v. Esurance. As we all know, the one-year back rule, or MCL 500-31145, indicates that if notice has been given or payment has been made, an action may be commenced at any time within 1 year after the most recent allowable expense, work loss, survivor's loss has been incurred. However, a claimant may not recover benefits for any portion of the loss incurred more than 1 year before the date on which the action was commenced. So, take that filing date and go back 1 year. For example, if the filing date is today's broadcast or the broadcast date of May 25th, 2023, you go back to May 25th, 2022, and anything before that may not be recovered. Now, a period of limitations applicable under this section to the commencement of an action and the recovery of benefits is told from the date a specific claim for payment of benefits until the date the insurer formally denies the claim. So that is a new portion of the one-year back rule that was brought about by no-fault reform. Further, the one-year back rule goes on to talk about notice and how to provide notice. That's really not the issue in these continued cases, but if someone does want to talk about or would like for me to discuss more notice requirements, please feel free to shoot me an email and let me know, because there's case law on point for that as well, obviously. Now, the case of Encompass Healthcare v. Citizens, which is a published opinion of the Court of Appeals, deals with how and when a claim is formally denied, thereby triggering the one-year back rule. Ultimately here, the court applied the one-year back rule and indicated that it remains tolled until a lawsuit is filed where there has not been a formal denial of the claim. The Court of Appeals here referred to the 2019 amendment that added that specific tolling period to the one-year back rule until an insurer's formal denial of a claim. In lay terms, until there's a formal denial of a claim, application of the one-year back rule remains tolled until the plaintiff files that lawsuit. Now, moving on to the recent unpublished opinion, Spine Specialists of Michigan v. Esurance. As we all know, prior to the 2019 amendment of the No Fault Act, if a claimant submitted a claim and the 1-year back deadline was approaching, they would have to file a lawsuit to protect their right to seek payment. However, this case states that the 1-year back rule is now tolled or paused from the date a claim is submitted until the insurer formally denies the claim, which means that claimants have more time to file a lawsuit if their claim is denied. So taken together in conjunction, these cases basically indicate that formal denial of a claim is important. And if an insurer is going to formally deny a claim and they've decided to do so, it's important to do so as soon as possible. So if there are 1-year back issues, that they are preserved and can be defended. And that is all I have for you guys for the May 2023 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway, and I welcome any questions and or concerns. Thank you.